Do you need a quick refresher on company formation? You have come to the right place. You will find here a quick introduction to what you need to know about selecting forms of business organization, presented through accessible examples and case studies. We start by presenting the different forms of business organizations available in the UK. We continue by introducing the notion of a company and presenting the different types of companies that are available. We will then discuss the rights of shareholders and the obligations they have in the running of private limited companies. Let me introduce you to Anna and Conrad. They are inventors. They have come up with a novel door ring camera. They have manufactured a few of the cameras in Anna's workshop and now want to start selling them. They are thinking about the best way to go about building a business. Should they start selling as traders, partner up in a formal way, or set up a company? This podcast has been prepared by Dr. ioannis.glinavos with the help of artificial intelligence tools. Get in touch with Ioannis by following the information on the description of this video to learn more about how the podcast was put together.
In English law, there is not a great deal of formality required to commence business activity. One could simply produce and sell goods or offer services as a sole trader. This means that someone is entitled to engage in business directly without obtaining permissions from the authorities or registering with the tax authority, the HMRC, in advance of commencing operations for the majority of commercial and retail operations. We will have the chance later in the podcast series to discuss licensing and the personal tax implications of operating a business, but for the moment we can start with the key aspects of operating as a sole trader. The key feature of running a business as a sole trader is that there is no distinction between personal and business finances. The wealth and assets of the person engaged in the business and their personal assets are not distinct and are liable to be spent to satisfy claims by customers, pay costs or settle tax and regulatory charges. The ease of doing business under one's own name therefore is counterbalanced by the danger that any liabilities attaching to the business also attach to the person running it. In more technical terms, we could say that operating as a sole trader offers no limitation of liability and no legal firewall between business and personal finances. It is precisely this feature that leads the majority of entrepreneurs to select other, more structured forms of business organizations through which to pursue their business activities. English law provides two main vehicles for pursuing a business for profit: companies and partnerships. We can begin advising Anna and Conrad by explaining what the meaning of these terms is. The term company normally implies an association of a number of people for some common purpose, but a single person can also form a company. You should not be left with the impression that companies are only suitable for large groups of persons coming together. The EU has put the matter beyond doubt with the passage of the 12th Company Law Directive. The purpose of a company will normally be of an economic nature. We are normally thinking of companies as businesses. The law on partnerships has different origins and is largely contained in legislation dating from the 19th century. This form of business organization is based on the idea that each partner becomes an agent of the other and can therefore act to bind the partnership. Therefore, partnerships are normally suitable vehicles for small numbers of people who have trust and confidence in each other. There is also an assumption that the partners remain stable. Note that there are tax advantages to different forms of business organization that will affect partnerships and companies differently. Tax concerns will affect the choices someone in the position of our inventors Anna and Conrad will make. Companies are commonly chosen as the appropriate form for larger associations with fluctuating membership. Such elements require that a corporate personality is created for the company distinct from that of its shareholders. The company becomes a separate legal person. The law governing companies is largely contained in the Companies Act of 2006. One of the key differences between companies and partnerships is the presence or absence of limited liability. Limited liability means that shareholders are not liable for the debts of a company. They only stand to lose out money they already invested by buying shares. No loss accrues to them beyond what they have already invested if the company fails. Companies can have limited liability, while a standard partnership does not. Partners share in profits and debts equally. However, a hybrid form of business was introduced by the Limited Liability Partnerships Act 2000. This statute enables the creation of a limited liability partnership, LLP. This LLP is in fact a lot closer to companies than it is to traditional style partnerships. An LLP has separate legal personality and limited liability, like a limited company, but for tax purposes and in internal decision-making process, it operates like a partnership. In other words, there is no separation between the roles of partner, member, and director in an LLP, and its members have freedom to decide on their internal decision-making structures. The LLP has proved successful for professional services businesses, for example solicitors. We have assumed so far that Anna and Conrad want to run a business and have a profit-making motive. But let's assume for a moment that the inventors are not really interested in money, and their main aim is improving home security for the benefit of the wider public. What if they want to make their product available for free, or at cost to save the planet and their country? If their aim is one public interest, but they do not want to set up a charity, Anna and Conrad could set up a community interest company under the Companies, Audit, Investigations and Community Enterprise Act 2004. Community interest companies, CICS, are limited companies, with special additional features, created for the use of people who want to conduct a business or other activity for community benefit, and not purely for private advantage. This is achieved by community interest test and asset lock, which ensure that the CIC is established for community purposes and the assets and profits are dedicated to these purposes. Registration of a company as a CIC must be approved by the regulator, who also has a continuing monitoring and enforcement role. This is a useful vehicle for purposes which do not fall under the legal definition of charitable purposes, and they are in the public interest, or alternatively they are of private interest, but do not seek to result in profit, for example tenants' association for the maintenance of a building. Of course, if our inventor aims come under the definition of a charitable purpose, then they could register a charity, charitable incorporated organization, under the Charities Act. One of the key features of companies is that the liability of their members can be limited. This means that the shareholders are not liable for the debts of the company. There are two means via which liability can be contained. One is to create a company limited by shares, the other by guarantee. Tauhe Companies Act does not permit a company to be formed where its members are completely free from all liability. The most common way to limit liability is to set up a company with its capital divided in shares. Each member purchases some shares. The money they spent represents the total commitment to the business. If the business goes under, they cannot recoup the value of their investment, but if the company leaves behind debts, the creditors cannot come to the shareholders and ask them to pay up. A similar way of achieving the same result is to limit liability by guarantee, popular for charitable, quasi-charitable organizations like schools and supporters Friends of Arts and Museums. A guarantee binds members to an agreement that in the event of liquidation they will, if required, pay up to specified amount. People may wish to have a company limited by guarantee as a less complex alternative to setting up a trust. Why prefer not have shares? If the purpose is not to make a profit, and therefore not to divide up this profit to the members, there is no purpose to having shares, one of the main attributes of which is the payment of dividends. Also, the guarantee does not require that anyone puts money up front. A guarantee only activates when things go wrong, as opposed to shares that are normally fully paid at the point of registration. One consequence of limitation by guarantee is that one can leave the company by resigning. In a company limited by shares, on the other hand, one cannot resign a share but needs to find someone to transfer it. We also need to address the fundamental distinction between public v. private companies. There are many characteristics that companies can have that sometimes overlap, but often do not. When people are asked what they know about companies, they will normally mention the concept of limited liability and the ability to offer shares for sale to the public at large. There is a lot of talk of a shareholding democracy, for instance, the idea that the public can participate in the success of capitalism at home and abroad. It is not necessary, however, that a limited company is a public company, and even if it were, it is not necessary that a public company offers its shares in a stock market, like London Stock Exchange, LSE. All these are important distinctions for a series of reasons. The treatment under the Companies Act in some respects differs, and also the stock exchanges have a myriad rules that they apply to their listed companies. How would Anna and Conrad select from all these options? We have already discussed that our inventors will need to think about whether they want a company, whether that company should be limited or unlimited, and what type of limitation, by guarantee or shares, they want to go for. If they opt for a limited company by shares, should it be a private company or a public one? The key thing to know is that private companies are not allowed to offer their shares to the public. This includes an offer that can result in people acquiring shares outside those contained in the offer. What is the meaning of private in this context? A private company is one where someone is already connected with the business. Connected persons with the company are members, employees, family, debenture holders, creditors, trustees. Public companies bring in any member of the public that wishes to purchase shares in the business. They are as a result more tightly regulated. The regulatory framework for public companies is not only in the Companies Act, but also in the Financial Services and Markets Act 2000 and Financial Services Act 2012. Still, English law does not have separate mechanisms to distinguish between the two, like in some continental jurisdictions. Even if Anna and Conrad opt for establishing a public company, it is not necessary that its shares will be traded at an exchange. A public company and a listed company are two different things. Statutory created bodies will create several regulations, and the stock exchange rules will all apply in different ways to publicly listed companies. For instance, a company wishing to have its shares traded in the LSE will need to have them admitted to the official list of securities, maintained by the FCA in its capacity as UK listing authority. UKLA regulates entry to the stock market in the interests of protecting shareholders through the release of information about the company. Further, stock market rules govern the company's conduct after listing. These contain provisions on related party transactions, significant transactions, and more that supplement provisions in the Companies Act. Also, these rules provide the legal basis for the UK Corporate Governance Code, a set of best practice guidelines that inform the behaviour of boards in public listed corporations at the LSE. The focus of this episode is small and medium-sized enterprises. We will focus therefore on aspects of shareholding for private limited companies, or LTDs. The key feature of incorporation as a private limited company is for its owners, the shareholders, to benefit from limited liability. The idea, as we discussed above, is that members of the company, shareholders, are not responsible for the debts and other obligations of the company. The doctrine of limited liability therefore shields shareholders from personal liability as long as the company is a going concern, and from the debts when the company goes insolvent. Liability can only remain in relation to any non-paid shares at the nominal value or guarantees if the company is one limited by guarantee. The rationale for limited liability is that it encourages investment from intercompanies by buyers of their shares. At the same time, however, it discourages loans to the company, as the creditor's chance to recover the loan depends on the financials of the company itself, as opposed to its members. Because of incorporation and the associated doctrine of the company's separate legal personality, a company can own property, sue and be sued. Crucially, a company, being a legal creation, is perpetual and is not affected by the physical death of any of its members. A great benefit of incorporation is the transferability of the company's shares to new owners. In the absence of any provision to the contrary in the company's constitution, shares are freely transferable, and someone can stop being a shareholder simply by transferring their shares to someone else. Note, however, that a private company cannot offer its shares for sale to the public, but transfer is still possible, while public companies can sell to whomever. Private companies therefore have determined shareholders. They are the ones who set them up. And in those there is normally no separation between ownership and control, as the same people tend to be shareholders and directors. As the relationship between shareholders in a public company is essentially impersonal and financial, there is usually no reason to restrict changes in membership, and usually shareholders and directors are distinct. Management under a board structure is another advantage of incorporation. Shareholders do not need to be directors, tasked managing the company. They can indeed do very little. It is in fact believed that a business is run most efficiently when control and cash flow rights are vested in the same party, or, when they are vested in different groups, if there is a clear definition of the rights and responsibilities of the respective parties. An example would be where control rights are vested in management and cash flow rights vested in shareholders. In large companies, separating ownership from control is essential in securing liquidity, as investment is needed from multiple sources, at substantial levels, and all shareholders cannot reasonably be expected to participate in every day-to-day management decision. How companies determine their management structures is up to them. There is considerable freedom in this respect in English law, but in the case of listed companies, a lot of guidance is provided by the Code on Corporate Governance. The UK Corporate Governance Code sets out standards of good practice in relation to board leadership and effectiveness, remuneration, accountability, and relations with shareholders. All companies with a listing of equity shares in the UK are required under the listing rules to report on how they have applied the code in their annual report and accounts. The code contains broad principles and more specific provisions. Listed companies are required to report on how they have applied the main principles of the code, and either to confirm that they have complied with the code's provisions or, where they have not, to provide an explanation. The idea behind this arrangement is that companies determine how they are run, and then the law steps in to determine how those with the power, privately allocated, get to exercise it. For example, how the directors perform their functions. The most important document in regulating the company's behavior is its Articles of Association. The Companies Act defines the Constitution as including the Articles of Association, but not limited to them, any special resolutions, or shareholder agreements. The legal status of the Constitution is contractual in nature. Tau-he provisions of the company's constitution bind the company and its members to the same extent as if there were covenants on the part of the company and of each member to observe it. This means that the constitution works as a multi-party contract between the company members and members with each other, therefore there is no privity problem in the acquisition of rights. Unlike a contract, however, the constitution is a public document. The articles are a public document, either because they are based on the statutory models that are already public, or because the company supplies to the registrar for public registration its own documents. Publicity of the articles is a traditional requirement in English law and also a requirement of European law. The articles, even though contracts at core, they are not interpreted exactly in the same way as normal contracts. The reason for this is the expectation that the articles give an accurate impression of what the company's managing mechanism is, in a way that is obvious to third parties. The courts therefore cannot imply terms into the articles, in the way that they would into contracts to give effect to the intentions of the parties. Similarly, the articles are not defeasible on the grounds of misrepresentation, mistake, undue influence or duress. As we mentioned above, a great deal about the company's running is left to be determined by the company itself, and the result of this determination is reflected in the articles. They will deal with matters such as the division of powers between shareholders and the board of directors, the composition, structure and operation of the board. As the shareholders control the constitution of the company, then they are the ultimate source of managerial authority within the company, and the directors obtain their powers by a process of delegation from the shareholders. Parties to the contract can enforce obligations contained in the articles. Parties to this contract are the members of the company. The directors of the company, in their sole capacity as directors, and not also shareholders, cannot therefore enforce obligations in the articles. A member therefore can enforce obligations only if they confer a benefit to him as a member at the relevant time. A third party who subsequently becomes a member does not acquire standing to sue on pre-existing obligations. An outsider to whom rights purport to be given by the articles in his capacity as an outsider cannot sue on those rights, treating them as contracts between himself and the company if he subsequently becomes a member. Subsequently, only if a director has a separate contract with the company can he expect to be compensated. For instance, reference to compensation in the articles does not constitute contractual entitlement. The Companies Act facilitates the process of drafting the articles by offering model articles of association for different types of companies. Model articles will apply to all new companies incorporating under the Companies Act 2006. These can be accessed on the Companies House website and via relevant legislation. Of course, regardless of whether the model has been adopted fully or personalized, subsequent amendments are possible. The articles normally specify a procedure whereby amendments can be made. A two-thirds majority of members can then alter the articles by following this procedure. The law protects the minority in two key ways. 1. The consent of an individual member is required for any increase in liability, obligation to subscribe for more shares. 2. Shareholders can entrench provisions of the company's constitution and make them subject to special procedures before amendment. Another way of altering company behavior, without amending the articles, is in the form of shareholder agreements. The advantage of those is that they can remain private and do not need to be registered in Companies House. On the other hand, as private agreements, they do not bind parties beyond them. There are different types of shares that a company can issue. A key lever in understanding the functions of shares is to remind ourselves that shares are property rights. As such, members do not have to vote their shares with the interests of the company in mind. They can do as they wish with their property, which translates as they can vote for their personal interests even if these are at odds with the company's interests. Ordinary shares are those without any attributes to distinguish them from the rest. Ordinary shares are a very flexible form of finance for a company because they entitle shareholders to no specific level of return by way of dividend, while shareholders cannot withdraw their contribution without the company's consent at issue. redeemable shares, or via an offer to repurchase on a later date. Some controversy exists on whether shares ought to be treated as property rights, or whether they should be perceived to be investments, and as such primarily bundles of contractual rights. The position in English law veers towards maintaining the share status as proprietary rights. The value that the company receives may represent less, however, than the total value of its assets, as the company can raise money from sources other than the shareholders, e.g., by borrowing from a bank. Even if it has not yet started trading, if it has started trading, the company's accounts will contain any profits over and above loans and share value. Value beyond that contained in the shares is not part of the company's capital. The reason for this is that all assets are transient, and the shares are the core of the value that exists to satisfy creditors if things go wrong. Despite the importance placed on the value of the shares, as the company's capital, however, English law does not heavily regulate minimum capital. Only public companies need to have that minimum, currently set at £50,000. This requirement came from the EU's Second Company Law Directive. Obtaining the minimum capital is a condition for getting the trading certificate for a public company, therefore it is a very significant requirement. If a company has started trading without the certificate, it is liable to a fine, as is any of its officers in default. Third parties, however, are protected, in the sense that any transactions entered by the company are valid, but if the company fails to comply with its obligations, the directors are jointly and severally liable to indemnify any losses suffered by the third party. When a company is formed, a company limited by shares, the application for registration must contain a statement of capital and initial shareholdings, the total number of shares to be taken on formation by the subscribers to the Memorandum of Association, their nominal value, the particulars of the rights attached to the shares, the number of shares taken by each subscriber, and the amount immediately paid up for the shares. Often this will be 2 shares of £1 taken by 2 people upon which nothing is yet paid up, as the subscribers are the employees of a company that promotes companies, and what they are doing is just setting up a shell company. When more substantial numbers of shares are issued subsequently, information needs to be given to the registrar, return of allotments, and data needs to be provided about those who got the shares, rights and obligations attached to these shares, classes of shares. All this is public information. This, of course, is only a disclosure obligation, not a state control as to what the company should actually do. Shares not only represent an ownership stake in a company but are also sources of income for shareholders in the form of dividends and distributions. What is a distribution? The most common form is the yearly or twice-yearly payment of a dividend by a company to its shareholders, usually in cash, but sometimes with additional shares. The law sets some rough limits on the ability of the company to distribute its profits to its shareholders. For example, company cannot distribute value if its net balance is negative, and it cannot distribute profits if that means that its net value will fall below its legal capital requirement. So long as the company respects that basic framework, it is free to deal with its excess funds in whichever way it wishes, reinvest, or give it back to shareholders. Such payments can be very significant. The reason for handsome payouts is that the company is owned by the shareholders, and this is how they recoup their investment. We are used to consider shares in a purely transactional manner, buy low, sell high. This is only relevant to public listed companies, and a lot of shareholders keep shares in private companies to benefit from the income generated via dividends and distributions. The internal procedure for authorizing such payments will be detailed in the Articles of Association. The model articles require both a recommendation from the board and shareholder approval. The shareholders, however, are not permitted to approve a level of dividend above that recommended by the directors. The issue of how companies can be managed in an effective way and what the role of law is in assisting this to happen is a crucial question of company law. The result is a developing literature on corporate governance that seeks to address command and control issues for big corporations where the shareholders are very much distinct from the board of directors, which itself may be distinct from professional managers who run the firm's day-to-day operations. How the whole system comes together and the relationships between the constituent parts of the corporate organization is part of an expanding literature. The larger a corporation gets, and the more diverse its shareholding, the more difficult it becomes for shareholders as a body to manage the firm. Therefore, effective management is promoted in English law by including provisions in the company's Articles of Association giving the board of directors extensive power to manage the company's business and to exercise its powers. Who are the directors supposed to run the company for? The director's primary accountability is to the company's shareholders, up to the point of insolvency, when accountability to the creditors becomes the primary focus. There are, however, as we will see, other groups that have a connection to the company, other stakeholders, as they are called. A development of a doctrine of corporate social responsibility implies obligations to groups outside the firm's shareholders, to people like employees, the community, the nation, the environment. There are some areas of decision-making that the involvement of the shareholders is mandatory. The general meeting needs to approve the board's decision. These are alterations to the Articles of Association, changing the type of incorporation, decisions to issue shares, decision to repurchase shares, reduce capital, give financial assistance, private companies, alterations of class rights, voluntary winding up. For public companies, the general meeting has to participate in the appointment of auditor, certain transactions entered into by the directors with the company, taking of corporate opportunities by directors, defensive measures in case of takeover bids, and approving transactions beyond certain size, exceeding 25% of the company's assets, profits or capital depending on the circumstances. Last, but not least, the general meeting can always with an ordinary resolution elect to dismiss the board of directors.
So far in this podcast we were introduced to inventors Anna and Conrad. They both believe that their door camera invention will make them rich beyond their wildest dreams, and they are thinking about the best ways to go about exploiting the potential of their product. Of course, if Anna and Conrad want to make this product a gift to the world, they could consider if they want to set up a charitable company, or they could consider a community interest company. If they decide that a company is a good vehicle for this purpose, they will still need to consider the following: should they go for a limited or an unlimited company?
To summarize, an unlimited company does not distinguish between the assets of the company and the assets of its members. The shareholders therefore are subject to liability for the debts of the company without a cut-off point. Why would anyone therefore choose to have an unlimited company? Maybe one does not need the feature of limited liability. If one sets up a consultancy, for instance, to offer teaching at universities on specialist matters on a sessional basis, then there is little risk that such company will incur debts or risk liabilities of the professional negligence variety. There are in fact a few advantages to an unlimited company. It can return capital to shareholders more easily than its limited sibling. The prohibition against a company acquiring its own shares only applies to limited companies, for instance, and there is no requirement to make public information on the company's financial position. The absence of limited liability may even make the company appear a safer investment in certain industries and would eliminate the need for guarantors if the business were to seek bank loans. If Anna and Conrad opt for a limited company, then they have the following choices open to them. Should their company be limited by shares or limited by guarantee? As we saw in the previous lecture, a guarantee only activates when things go wrong, as opposed to shares that are normally fully paid at the point of registration. One significant consequence of limitation by guarantee is that one can leave the company by resigning. In a company limited by shares, on the other hand, one cannot resign a share but needs to find someone to transfer it to. Once they have decided on the type of limitation, they should also consider whether the company should be a private or a public one. The choice has to do with what economic purpose the company serves. Public companies raise finance from the public at large, while private companies rely on a limited initial investment from a defined number of people. Companies usually incorporate as private and may become public at a later stage when the company needs influx of investment to grow. If a company wants to register as public initially, they will have to comply with more complex incorporation requirements. The name of the company is very important, as a company becomes an independent creature with its own legal personality, separate to that of its owners and managers. The name has huge marketing significance. If Anna and Conrad opt to set up a private limited company, on the application for registration they will need to state the company's proposed name, so that after incorporation they can give adequate publicity to their business venture. To market effectively, the name should be something short and well considered, as a change of name is a complex process and one that is bound to confuse and alienate customers. In fact, a maximum of 160 characters are allowed. If the company is to be limited, then the name must end with the suffix limited or public limited company. Could Anna and Conrad pick absolutely anything as their company's name? The short answer is no, as there are restrictions, controls and requirements for approval of certain words and expressions when used in a company name, rules on punctuation and permitted characters, sensitive words and expressions. There are also rules on name endings depending on company type. Names that imply a connection with any part of government are not allowed. In order to make a selection, Anna and Conrad will start by going through a process similar to what is known as search engine optimization, whereby one searches for certain keywords to see what comes up on internet search engines. For company names, this is best carried out through the company's house. This service ensures that our inventor's chosen name is not the same as an existing name on the index of company names. Anna and Conrad should also check the Trademarks Register of the UK Intellectual Property Office to ensure that the proposed name does not infringe an existing trademark. Let us take our inventors through this process, step by step. As mentioned already, Anna and Conrad are not completely free to choose any name they want for their proposed company. If their company is to be a private company limited by shares or guarantee, its name must end with Limited or Ltd. If they opt for a public company, straight away, its name must end with Public Limited Company or PLC. Legislation sets out the controls and restrictions on the choice of company name. There is a requirement that certain expressions and abbreviations which describe a particular form of company can only be used at the end of a name, such as Public Limited Company or Community Interest Company. There are rules which prevent the registration of a name which is the same as an existing name on the index. There are also controls over the use of certain characters, signs, symbols, and punctuation in a company name. As mentioned already, names that suggest a connection with His Majesty's government, a devolved government or administration, or a specified public authority are not allowed. Names that include sensitive words and expressions included in regulations, and names that include words that would constitute an offence and offensive names are also excluded. It is worth exploring further what is meant by same as. If two company names are so similar, they are likely to confuse the public as to which company is which, then they are the same as. To determine whether a name is the same as an existing name, regulations set out the words and expressions that must be disregarded and the words, expressions, signs and symbols that are to be regarded as the same. For example, designated name endings, including permitted abbreviations, are not considered when examining similarity. Certain words and expressions are also excluded from consideration. These include biz, co, co.uk, com, company, UK, United Kingdom, net, org.uk, services, international, blank space between or after a word, expression, character, sign or symbol, and punctuation. The consequence of these rules is that one can register a domain name as a company name. The registrar will not reject it for containing a URL. Some words and expressions will be regarded as the same as, preventing people from easily circumventing the rules. For example, and, the and sign, plus, and, the sign plus, the number 1, and, the word 1, etc. are considered the same. There are, however, some exceptions to the same as rules. The rules do not apply when the proposed company will be part of the same group as an existing company, and the existing company consents to the registration of the proposed name. The application to register will need to include a statement from the existing company which confirms its consent to the incorporation of the new company name or that it will form part of the same group. Certain words and expressions cannot be used as part of a company name. This is to avoid the situation where a phrase included in a company or business name could suggest business preeminence, a particular status, or a specific function, imply a connection with a government department, devolved administration, or public authority, or cause a criminal offence. These rules are in place to protect the public from being misled. There are a list of such sensitive words in the company, limited liability partnership and business names, sensitive words and expressions, Regulations 2009, SI number 2615. Also see the company, limited liability partnership and business names, public authorities, Regulations 2009, SI number 2982. Even if Anna and Conrad adhere to all these rules and select a name that they believe to be appropriate, they could still be required to change their company name after incorporation if the name is too like an existing name on the index, misleading information was provided at the time of registration, the company's activities are misleading, the company no longer justifies omitting limited from its name, or the name is too similar to a name in which someone else has goodwill. They could be directed to change their company name within 5 years of incorporation if misleading information was provided to enable the name to be registered or if an undertaking or assurance given to enable the adoption of the name has not been fulfilled. A typical example would be a company whose name and stated activities suggested it was providing training courses that the public believed would lead to a recognized qualification, Whether a name is too like another is a similar, but not the same test as the one we encountered before in relation to same as names. In general, a name is too like an existing name if the differences are so trivial the public are likely to be confused by the simultaneous appearance of both names on the index, and/or the names look and sound the same. Names that differ by the inclusion of additional words, as opposed to a few characters, will not be treated as too like, regardless of whether the additional word does or does not describe an activity in detail. However, names that differ only by the inclusion of words that are normally associated with a name ending such as company or partnership will be regarded as too like. When choosing their proposed name, Anna and Conrad should check the index to ensure it will not result in an objection for too like, which could require them to change their company name. Not all too like names result in an objection but could incur additional costs, for example, new signage, business stationery, and also damage to the goodwill you have gained since incorporation. It is also worth noting that English law does not allow opportunistic registrations. This is unlike domain name registrations, for example, where the first person to claim the name owns it. Opportunistic registration is the term applied to a company or LLP which registers a similar name to one in which another person has goodwill. There is no restriction on who can complain. Complaints about opportunistic registration are handled by the Company Names Tribunal, not Companies House, which provides a remedy for parties who suffer damage by the registration of a company or LLP name in which they have a goodwill reputation. Objections are also based on the suspicion that the name has been registered in order to extract money or to prevent the aggrieved party from registering the name. Anna and Conrad should be aware of the difference between their company's name and a business name. A business name is any name under which someone carries on business other than their own. In the case of a company or limited liability partnership, it means a name that is not its registered name. In the case of a sole trader, it means a name other than a surname with or without forenames or initials. In the case of a partnership, it means a name other than the partners' names. Business names are not registered under the Companies Act, but some of the rules included in the Act do apply, principally restrictions on the use of certain words in the name and names that could imply a connection with a government department or public body, inappropriate and misleading use of a name ending, e.g., limited, at the end of the name. As we have seen earlier, there are rules to prevent the use of names that could mislead the public, and additional rules requiring the names of sole traders and partnerships using a business name to display it on stationery and signs at business premises. Once Anna and Conrad have selected the company's name and are ready to proceed with their registration application, they should be made aware of how they must publicize information about their new company. Regulations made under the Companies Act 2006 require a company to display its name at its registered office and other places of business, on business documents and on websites. The purpose of the regulations is that the legal identity of every company should be revealed to anyone who have, or may wish to have, dealings with it. Every company, unless it has been continuously dormant since incorporation, must display a sign with its registered name at its registered office, any inspection place, at any location at which it carries on business, unless it is primarily used for living accommodation. It must also include its registered name in all business communications, hard copy and electronic. If Anna and Conrad open a physical office or shop, they will need to display a sign with the company name in characters that can be read with the naked eye, in such a way that visitors to that office, place or location may easily see it. They must also include the company's registered name in all forms of business correspondence and documentation, whether in hard copy or electronic, including business letters, notices and other official publications, business emails, checks purporting to be signed by or on behalf of the company, bills, invoices and other demands for payment, receipts and letters of credit. The company name must also be displayed on the business website. While there is no need to include the company name on every page, it must be displayed so it can be easily read. There are also a number of other items of information that a company must communicate to the public. A company must display, key amongst other required information, on all its business letters, order forms and websites the part of the United Kingdom in which the company is registered, the company's registered number, the address of the company's registered office, if a company is exempt from the requirement to use limited in its name, the fact that it is a limited company. If anyone with whom the company deals in the course of business makes a written request for the address of its registered office, the address of any place of inspection, the type of company records kept at the registered office or inspection place, the company must provide this information, in writing, within 5 working days. It is not necessary, however, for the company to state the directors' names on its business letters unless it chooses to do so. Nevertheless, if it does decide to include the names, then it must state the names of all its directors. In other words, a company cannot be selective about which directors' names it shows. It must show all of them or none of them. To incorporate their company, Anna and Conrad must file the following documents: an application to register a company, Form IN01, and pay a fee of £12 for an online application or £40 for a paper one, submit the Memorandum of Association, Articles of Association, and additional information if their choice of name includes a sensitive word or expression. Checking carefully existing names and the rules we discussed earlier on name selection is very important, as it is not possible to reserve a name. The application to register a company, Form IN01, requires the following information: the proposed company name, the location of the company's registered office, it may be in England, Wales, Scotland or Northern Ireland, the address of the registered office, whether the company will be private, public or unlimited, choice of articles of association, details of the proposed directors, and the company secretary, if there is to be one, the director's service and residential addresses, a statement of capital and initial shareholdings or a statement of guarantee, notification if the proposed name contains a sensitive word with the confirmation that the views of a government department or other body have been requested, and finally a statement of compliance or guarantee. Anna and Conrad will also need to select a relevant SIC code for their business. This is the Standard Industrial Classification of Economic Activities Code. A condensed list of SIC codes for providing a description of a company's nature of business is offered by Companies House. The Memorandum of Association confirms the subscriber's intention to form a company and become members of that company on formation. In the case of a company that is to be limited by shares, the memorandum will also provide evidence of the members' agreement to take at least one share each in the company. Under the Companies Act 2006, the memorandum is a much shorter document because all the constitutional rules of the company are contained in the Articles of Association. Consequently, the memorandum serves a more limited purpose, and once the company has been incorporated, it cannot be amended. The required memorandum wording is included in the Company's Registration Regulations 2008, 3014, and Anna and Conrad must use this format when preparing their memorandum. As we have seen in our previous episode, the company's Articles of Association are its internal rulebook, chosen by its members. Every company is required to have articles, which are legally binding on the company and all of its members. The articles help to ensure the company's business runs as smoothly and efficiently as possible and will set out how decisions are taken by the members and directors as well as various matters connected with the shares. The articles cannot contain rules that are against the law. Provided the members observe this general principle, they have complete freedom to choose which rules are included in the company's articles, although they may find it convenient to rely on model articles as a default position. On incorporation, a company can adopt model articles in their entirety, model articles with amendments, or it can draft its own bespoke articles. What if Anna and Conrad want things very simple and are in a hurry to start their business? With new online submissions of documents, it is very fast to set up a company. In earlier eras where things were more time-consuming, a popular method to start a business fast was to buy an off-the-shelf company. One that is pre-incorporated and then make amendments to its articles and name as appropriate. You may have encountered the terms off-the-shelf company and shell company. An off-the-shelf company is one created by a company formation agent, known as promoter in English law, and held as dormant, pending onward sale to a new business or to a sole proprietor or partnership wishing to become a limited company. A shell company is a company bought off the shelf with nominee directors standing in front of whoever really benefits. When the incorporation process is complete, the registrar will issue a certificate of incorporation stating that the company is incorporated, giving its name and registered number, information on the date of incorporation, whether it is limited, whether it is public or private, and the jurisdiction in which its registered office is located. The effect of incorporation is that the members specified in the memorandum become the holders of the shares specified in the statement of capital, and the directors and secretary are appointed to their offices. The registrar decides whether to incorporate a company or not, and this is an administrative function subject to judicial review. However, once the company is incorporated, then its creation cannot be undone, as the certificate is taken as conclusive evidence of the company's existence. According to the Companies Act, this is all that is needed. A private company can begin to trade. A public company, on the other hand, is subject to some further requirements. A public company needs to obtain a further certificate of trading. This document certifies that the company's allotted share capital is not less than the required minimum, currently £50,000. A private party therefore cannot challenge the act of incorporation, but the Crown can, usually on grounds of public policy. Only the Crown can plead the nullity of a registered company. A company therefore exists, even if it suffers from some flaw of incorporation. The correct action to take in resolving a problem is to wind up the company. This is done to protect people who may have dealt with the company on the strength of the registration certificate. Finally, it is worth mentioning that Anna and Conrad could register for corporation tax when going through the steps of registering their company. Most companies register for corporation tax and pay as an employer at the same time as registering with Companies House. We will discuss details relating to tax in our following lectures. A company, as a legal fiction, needs the intervention of a human agent in order to come about. The persons tasked with creating or helping to create the company are called promoters. The expression promoter covers any individual or company that arranges for someone to become a director, places shares, or negotiates preliminary agreements with potential company members and third parties. Usually this is someone involved in the creation of the company, but this is not necessary. It could be that it is someone who subsequently helps to arrange the floating of the company in a stock market, most usually staff in an investment bank. Because there are many possibilities of abuse of the promoter's position, as they usually sell the company their services, or their business, before the company has independent decision-making structures, the courts have concluded that anyone in this position stands in a fiduciary position towards the company with all the duties of disclosure and accounting which that implies. A promoter is prohibited from making any profit out of the promotion without disclosing it to the company. Further, the law mandates that promoters are under a duty to ensure that the company has an independent board of directors and to make full disclosure to it, so that the board can exercise an independent and intelligent judgment on transactions. It is also possible that disclosure to those becoming members of the company is considered equally effective. Nevertheless, this carries the risk that the promoter discloses information to people they are already intimately connected with, and those are not likely to object if they are all participant in transactions aiming at personal, as opposed to corporate, enrichment. The legal position therefore is that disclosure needs to be made to the company, meaning to an entirely independent board, or to the existing and potential members as a whole. Further, the disclosure needs to be explicit. When a transaction generates a profit for the promoter, then the promoter as trustee needs to pass such profit on to the company or disclose any proposed profits and inform the company of its right to value the property at its cost price. However, when the promotion of the company involves offering shares to the public, then explicit disclosure requirements are set by legislation. If the promoter breaches his duties, then the remedy is for the company to bring proceedings for rescission of any contract with them or for the recovery of any secret profits which the promoters have made. The flip side of all these rules is that the only way a promoter can be paid for their services is if they have a contract with the company to that effect. The weakness with this is that the company before incorporation cannot enter into contracts, nor can it become liable for contracts made on its behalf. This leaves promoters in an arguably weak position in demanding subsequently payment for their services. A promoter has an action against any person with whom they have contracted personal liability and not against the company, unless the company subsequently ratifies the transaction. Actions taken by the promoter in setting up the company expose them to personal liability, which persists even if the company ratifies actions done by the promoter post its incorporation. In our scenario, Anna and Conrad would be the promoters and subsequent shareholders, members, and directors of the new company. It is unlikely that on these facts there would be conflicting interests between them and the newly formed company. We have discussed on a number of occasions that English law does not take a too prescriptive approach to controlling the organizational aspects of firms. The idea is that freedom of contract prevails, and that the firms themselves should adopt whatever structures they consider to be most appropriate to their business. However, minimal statutory requirements mean that there are expanded opportunities for abuse from the people tasked with managing the company. What is there to stop the directors of using the company as means of self-enrichment, rather than using it to benefit the shareholders? The key power of the shareholders is the one found in Section 168. They can dismiss the directors at any time by ordinary resolution. However, the law does contain a series of rules to prevent abuses and protect the shareholders. The 2006 Act contains these rules in Chapter 2 of Part 10 under the heading General Duties of the Directors. There has been a lively discussion on whether directors' duties ought to be static, enshrined in statute, or they would be better off left to the courts, so they can evolve alongside business practice. The duties of the directors are owed to the company both in common law and by statute, Section 170. Duties therefore are not owed to individual shareholders or employees. Only those who are able to act on behalf of the company can enforce the duties. The Companies Act lays out in detail the duties of the directors to their company. The most significant duty, and one that will be immediately of relevance to Anna and Conrad upon setting up the company, is the one contained in Section 172, which states that a director of a company must act in the way they consider, in good faith, would be most likely to promote the success of the company for the benefit of its members as a whole, and in doing so have regard, amongst other matters, to the likely consequences of any decision in the long term. The interests of the company's employees. The need to foster the company's business relationships with suppliers, customers, and others. The impact of the company's operations on the community and the environment. The desirability of the company maintaining a reputation for high standards of business conduct. And the need to act fairly as between members of the company. This provision is important because it forms the basis of the statutory acceptance of corporate social responsibility in English law. This is supposed to be a modernized version of shareholder primacy, including a series of other considerations that contribute to the long-term success of a company. This is also known as enlightened shareholder value. The idea behind this formulation is that the interests of the shareholders are unlikely to be advanced if the management of a company conducts its business so that its employees are unhappy, its suppliers and customers would rather avoid it, it is at odds with the community in which it is based, and its ethical and environmental standards are regarded to be unacceptable. Success is defined in commercial terms as there is an assumption that the company is a commercial company. The directors are expected to behave, subjective test, in the way they consider, in good faith, as the most likely to promote the success of the company. However, this is not to suggest that the interests of stakeholders are now at equal level with the interests of shareholders. The directors consider external interests to the extent that this is desirable to do so in order to promote the success of the company for the benefit of its members. The members' interests are still paramount. Not all companies that do business in the UK are incorporated under the Companies Act. A company incorporated outside the UK is called an overseas company. Legislation also deals with overseas companies with the aim of ensuring that there is availability in the UK of the same basic information about a company incorporated abroad which has an established presence in this country. There are therefore specific disclosure requirements for overseas companies having an establishment in the UK. Establishment can be defined in two ways: as branch or a place of business. A branch is a place of business through which the company directly conducts some or all of the operations inherent in the business. A branch therefore has the appearance of permanence and is physically equipped to negotiate business with third parties directly. A place of business, on the other hand, requires a degree of permanence or recognizability as being a location of the company's business. However, what gets done can be purely ancillary to the company's business, such as warehousing or data processing. An overseas company which opens an establishment in the UK needs to notify the registrar with information about it and its establishment. Failure to do so is a criminal offence but does not affect the validity of transactions conducted by the company. Generally, in English company law, there tend to be criminal penalties for violations, but the transactions themselves are not voided as this presumably protects market expectations. Having published contact information for a company ensures that one is able to serve documents if they want to bring action against them. Ongoing disclosure requirements contain those matching trading rules and annual reporting. Of course, overseas companies are still regulated according to the rules of their place of incorporation.
In this video, we were introduced to Anna and Conrad and helped them decide whether they should start selling as traders, partner up in a formal way, or set up a company. We then focused on the process of setting up a new company in the UK. We presented the necessary stages one needs to go through to set up a private limited company, and described the documentation required. We guided our inventors, Anna and Conrad, through the various choices they will need to make when setting up their new company. The episode explained how decisions are made on organizational structure, how to select a name, what type of information disclosure is needed and at which stage, what the steps are when one seeks to incorporate a company and at what cost. We also touched on the rights and obligations of promoters and directors, as well as options for overseas companies seeking establishment in the UK. Thank you for listening till the end of this podcast. Feel free to subscribe to the channel and click on one of the links of your screen for more in this series.